Sanjay, we have started with an act. The name of the act is called as General Clauses Act 1897. I'm revising what we had discussed earlier. So, General Clauses Act 1897. This is our concept. So, before General Clauses Act 1897, in India, two more General Clauses Acts are there. One is General Clauses Act 1868 and a General Clauses Act 1887. In the year of 1897, what we had decided, we should combine these two acts and we can frame the another act as nothing but General Clauses Act. So what is the main purpose of this act? What is the main purpose, sir? Sir, so many acts, definitions are not defined. Section 2 में definition है तो no problem for us. But some acts definitions are not defined, then they can refer the other acts. Even though there is no reference of other acts, then you can follow the definitions which are defined under this act. That is the reason why General Clauses Act is nothing but it's an act for all the acts, act of all acts. Law of all the laws. This is the act of all the law acts. This is the law of all the laws. Like that, whenever any act there is no definition, then they can provide the definition not to maintain uniformity. Uniformity in case of definitions, this act was introduced. Or so acts in some acts, one definition is defined in one way, same definition, another act defined in another way. There is a conflict between the definition. First scenario, definitions are not defined, then you can define the definitions under this act. Definitions are defined under multiple times. There's a conflict arises, then how to solve that is also can be based on this particular act. That is the main purpose of this act. That is the intention to brought this act in India. This is also called as Central Act, law of all the laws and act for all the acts. After that, we had discussed about section 1. Section 1 is nothing but it's a common section in all the acts. What is the name of the act? The General Clauses Act 1897, where it is applicable. So applicability, generally area-wise applicability, another one is institutional-wise applicability. So area-wise applicability, so General Clauses Act is not having area-wise applicability situations. Why? Because so we are studying about Companies Act. Any definition is not defined under Companies Act. Then we will refer the General Clauses Act. We will refer General Clauses Act. So whenever for the definition, any definition is not defined under General Clauses Act, not defined under Companies Act, we will refer the General Clauses Act. At that point of situation, General Clauses applicability as per Companies Act. Suppose I am studying Negotiable Instrument Act. In Negotiable Instrument Act, definitions are not defined. One definition is not defined. Then I refer about which act as a General Clauses Act I will refer. In this scenario, General Clauses applicability based on Negotiable Instrument Act. Suppose I am studying Indian Contract Act. Indian contract, some definitions are not defined. Not defined. Then what happens? We will refer General Clauses Act. Now General Clauses Act applicability like Indian Contract Act. Sir, for which central act, you can refer the General Clauses Act. General Clauses Act applicability based on area-wise applicability based on central acts. This is a basic understanding. General Clauses Act applicability, area-wise applicable. But which areas? So which area you can applicable? Which area? Which area you can apply, sir? Based on central act. So I'm reading Companies Act. Now the definition is not defined under Companies Act. I go through with the General Clauses Act. Now general clause applicability as per Companies Act. I am studying an act, definition is not defined, and go through with the General Clauses Act, applicability of General Clauses Act as per an act. For which central act we go through with the reference, the area was applicability based on central acts. Institutional for whose, for what means applicable, where it is applicable, for which acts this act is applicable. So like that, this institutional related applicability, we are classified into three categories. Any acts are formed before 1868. Any central act is framed in India before 1868. Central act is framed between 1868 to 1887. Central acts are framed between 1887 to 1897, or central acts are framed after 1897. So for the applicable, so this act is applicable to all central acts, no doubt. This act is applicable to all central acts. But central acts, when the central act is formed, that is important. The central act is formed before 1868, this act is not applicable. The central acts are formed between 1868 to 1887, 1887 to 1897. Between these two periods, the central act is formed. For this central act, the General Clause Act applicable, partial applicability. Any act or formed after 1897, for this General Clauses Act is complete applicability. This is the applicability of the Central Act, applicability of the General Clauses Act we are discussed. Okay, so this is the act for all the acts, law for all the laws. After that, we are discussed about applicability, applicability area wise based on Central Act. After that, for which central acts are formed within the period, how this General Clauses Act is applicable. Some General Clauses Act is not applicable, some for partial applicability, some for complete applicability of General Clauses Act. Okay, so that is a concept we had discussed. After that, we had discussed about central government also. Central government, before constitution, what is central government? After constitution, what is central government? Before constitution, what is central government? So governor general. Okay, so governor general or provinces of governor general. So governor generals and provinces of governor generals is a before constitution. So after constitution, president of India, governors, chief commissionerate, and lieutenant governors of union territory. This all together it is called as central government. Before constitution and after constitution, we are discussed. While discussing about the central government, we are discussed about part A states, part B states, part C states, and part D states. Part D Andaman Nicobar only, part C states, part B states, and part A states. Part A is related to the means which are ruled by the governor generals of English and which are ruled by the governors of part A states. Governors are in which state they are having governors, and after that part B said Raj Pramukhs, and part C states are chief commissionerate. Part D Andaman Nicobar. Like that, we are discussed about the categories of part A, part B, part C, and part D states. These are the concepts we are discussed in the last class. Now, today we are continuing with another concept. So listen. Sir, as a student of law, we are studying law. Whenever we are reading any act, whatever may be the act, you want to means you are go through with the Companies Act, you are go through with the Negotiable Instrument Act, you are go through with the Indian Contract Act, you are go through with the LLP Limited Liability Partnership, you are go through with the SEBI Securities Exchange Board of India Act, you are go through with Securities Contract Regulation Act, you are go through with the Foreign Exchange Management Act. Whatever may be the acts, I wanted to study the law. I want to know the minimum basics related to how to study the law. What are the points? What are the means of how the lawmakers frame the law in India? So listen carefully. So first of all, how an act is formed in India. How an act is formed in India? Basically, how the act is formed. First of all, the bill is prepared. Bill is prepared. Bill is prepared by drafting committee. So bill is prepared by drafting committee. Drafting committee is there a group of professionals, chartered accountants, cost accountants, company secretary, advocates, the people who are sound knowledge in economics, current affairs, okay, international trade, like that. All people are there. There is be the members in a drafting committee. These people can prepare a bill. So the bill was sent to upper house. This bill was sent to upper house. So upper house का मतलब क्या है सर? राज्यसभा. Then in that particular upper house there is a voting. Then they can be passed in the upper house. After that the bill was sent to lower house, Lok Sabha. Lok Sabha. Then it is also there is a voting and also there is a discussion related to that particular matters and that can be passed in Lok Sabha. After that, that can be sent to the president. The president receive it, president gives his assent, gives his assent. The moment when president gives his assent, president gives his signature, that is the situation that can be published. The moment when president gives an assent, that can be published in official gazette. So published in official gazette. Okay, so official gazette is nothing but central government publication, Rajpatra. So the moment this is the moment when that can be given by president gives his assent, this is the situation. The bill becomes an act in India. This is a journey of a bill into an act. The drafting committee can prepare. So in this scenario, the president gives his assent. Then after that, the bill becomes an act. That is nothing but an act in India. So this is the way, sir. In case of company bill or GST, whatever it may be, they can initially they can prepare a bill. Initially, they can prepare a bill. After that, can be sent to the upper house. There is a discussion in the upper house, and there is arguments. They can change this, anything. They can voting. After that, lower house. After that, can be president. President gives his assent. Then there is nothing but the bill becomes an act. This is the journey of an act. Okay, sir. Listen carefully. The same scenario. Bill is prepared recently in India. What happened? Bill is prepared, which bill says is nothing but Kashmir Reorganization Act. Bill is prepared. What is that, sir? Kashmir Reorganization. Kashmir, right? So Kashmir Reorganization. Kashmir Reorganization Bill. Kashmir Reorganization. The bill was prepared by a drafting committee. Then the bill was sent to upper. How the bill becomes an act? Sir, the bill was sent to the upper house. After that, lower house. After that, president of India. But here, what happened? The Kashmir Reorganization Bill was prepared. Then there is no time to conduct the upper house and lower house meetings. Meeting in the sense, you should call for meeting. You should give a notice to all members of the parliament. At least 21 days notice is required. Then, as on those days, they can attend. Even though short term notice also 7 days, but 95% people are agreed. These are the concepts are there. But the bill was prepared, but there is no time to conduct the Lok Sabha and Rajya Sabha sessions. And there is not a time to conduct Lok Sabha and Rajya Sabha sessions. But at that point of situation, what happens, sir? The drafting committee directly they can prepare a bill. The bill was sent to the president. Then what president will is that president received the bill, president assented. that is not passed in Lok Sabha. Lok Sabha में pass नहीं हुआ, Rajya Sabha में भी pass नहीं हुआ, but directly that is went to the president. President gives his assent. Whenever the president gives his assent, in this scenario it is called as ordinance. It is not an act. It is an ordinance, sir. The ordinance is nothing but it is issued by the president without the Lok Sabha and Rajya Sabha approval. Okay, sir. After that, what happens, sir? This ordinance is prepared. That can be into the circulation. Now it is applicable in India. After that, that can be present in front of Lok Sabha. That can be present in front of Rajya Sabha. They are accepted. Then that will becomes an act. After that, it will. So first of all, president gives his assent. After that, Lok Sabha and Rajya Sabha approved. Then becomes an act. The moment when first president gives his assent, that is called as ordinance. Okay, that is called as ordinance. This is the way the bill becomes an act. What is the difference between the act and ordinance? Act may along with the president's and Lok Sabha and Rajya Sabha approval is required. But ordinance may Lok Sabha Rajya Sabha approval is nahi, then only a president assent, president approval is there. Then that is called as ordinance and bill becomes an act. There's a journey of a bill into the act and what is in this particular scenario after that. So when it is came into force, commencement, so commencement when the president gives his assent, that is the date of commencement. Since the act is sent to the president, president gives his assent. The moment when president gives his assent, president gives his assent, that is nothing but the act is came into force. That is commencement of act. Commencement of act. Clear, sir? Clear, sir? Now, everyone is clear? Tell me, sir, any doubt? So next we are discussed about whenever you are reading the law, first of all in laws, first of all, there is nothing but title is there. Title. Title is nothing but name of the act. Whenever you are reading the law, reading the act, first of all, title of the act is there. Section 1 may discuss with this thing title. So generally, title is two types. One is a short title, another one is a long title. Title in the sense there is a two types of titles are there. One is short title, another one is a long title. So short title का मतलब क्या है सर? So we are discussing Companies Act 2013. Okay, sir. Negotiable Instruments Act 1881. In case of upper, lower, not approved, that is ordinance only. So Companies Act 2013, Negotiable Instrument Act 1881, Indian Contract Act 1872. So these are all our short titles. These are not long titles. Simple way of understanding what this act deals. For what this act was introduced. So Companies Act 2013, what is that? It is introduced for companies in India. Negotiable Instrument Act 1882 is related to the negotiable instruments like bills of exchange, promissory note and check. Indian Contract Act 1872, it is related to the contracts. Like that, this is a short title, you're easy to understand. But another one is a long title. What is the long title? This act was incorporated for the promotion and incorporation matters related to companies in India. So this is the long title of Companies Act. This is a long title. Long title is like that. This is the long title. Whatever the acts we are mentioning, these are called as short titles. Every time we are mention short titles only, no need to mention long titles everywhere. In order to understand easy manner in easy way, we should mention short titles everywhere. This is the first stage in case of any law. So coming to, we are discussed about, sir, I will disclose one thing. Wait, I will disclose one thing. I can disclose, wait. So how this act was, what way that's. So Companies Act 2013, joined to section 1. What section 1 deals with? Simple scenario. Joins a short title and commencement. Short title, joins a short title. This act may be called as Companies Act. This is short title. This is short title, sir. Whatever we are discussing, there is nothing but short title of the act. But long title be there. There's a long title be there. Long title is nothing but this act is incorporated for the promotion and incorporation of companies in India. That is a long title of the act. It's a long title, sir. Is it? Negotiable Instrument Act. We go through with the Negotiable Instrument Act. So every act is a, first of all, we are discussed about what is the title. So it's a short title. Everything, every act is a first one is short title only. Whenever you are reading the law, first one is the short title. It's a short title. This act may be called as a Negotiable Instrument Act 1881. This is a short title. This is a long title. It's an act to define and amend the law relating to the promissory note, bills of exchange, and checks. This is called as a long title. Clear as sir? Long title is nothing but we can discuss elaborately, but short title is simple manner. This is the first scenario. We will read about any law. This is the first stage. It's nothing but short title and long title. This is the first. Next one, sir. Next one is nothing but preamble. So after the title in any act, they can mention preamble. So what is meant by preamble? Preamble means simple, sir. What purpose the act was incorporated? What purpose the act was incorporated? So, what purpose the act was incorporated, that can be mentioned. The preamble. Preamble is nothing but the main objective of the act. Simple examples. Simple example. Whenever I'm studying about Information Technology Act 2001. Information Technology Act 2001. I'm studying this particular act. While I'm reading this particular act, I can find the word virus. इसका मतलब क्या है sir? What is meant by virus? Whenever I am go through with Information Technology Act 2001, I can study the word virus. इसका मतलब क्या है sir? What is the meaning of virus here? Virus is nothing but a bug in the system. Yes or not? A bug in the system of computer. A bug in the system? Yes or no? Yes. Suppose same scenario, sir, same scenario. Suppose I am studying about the protection of. I am studying about protection of Environmental Act. Protection of Environment Act. So whenever Protection of Environment Act, can say Protection of Environment Act, I am studying about the word called as virus. So here, what is the meaning of virus? Virus is nothing but a disease is spreading situation. Disease is spreading systematic syndrome. No, that is called as virus here. Disease spreading syndrome. So like that here, whenever the same word, here may be virus, here also be virus, same spelling, same is there. But while I'm reading about information technology, the virus definition, the virus motive, the virus intention is different. But now I'm studying about this particular act. When I'm studying about this particular act, in this scenario, the definition of virus is different. How you will define here a virus means that is here the virus means that is how you will define that based on preamble. Preamble shows what is the purpose of this particular act. Based on that purpose, you will interpretation, you will identify, you will observe that particular word. Okay, so you will observe about that particular word only. So like that, the preamble, next step in the while whenever you are reading the law, next step is nothing but preamble. Purpose. What is the main purpose of the act? So if you are having confusion about any words during the act, you should refer the preamble. Then you will easily identify what purpose this act was introduced. Okay, so what purpose this act was introduced? So answer again. So here preamble, what is whereas it is expedient to define and amend the laws relating to the promissory note, bills of exchange and checks, it is hereby enacted as follows. Or in case of preamble, what is the preamble here? Sir? Not in this particular one, preamble is here on. Whereas it means what is the preamble of what purpose the act was introduced, the purpose clearly mentioned in the preamble. What is the importance of preamble? Whenever we are reading the law, we are getting confusion to identify the words. Then we should refer the preamble, then you can easily identify what purpose this act, what way this word is understandable to the person. Like that we will discuss. Okay, so that is nothing but preamble is the next part. In any act, next one. So next one is in act, there is a act, there is nothing but definitions. Section 2 is nothing but definition or not, yes. Section 2 gives a definitions. Clear? Listen. So in every act, sir, generally section 2 gives a definitions. That is the reason why this section is also called as a definitory section. But in this general clauses act, the definitions are defined under section 3 and section 4 also. So here basically the definitions are broadly classified into 3 categories. 3 categories of definitions. One definition, what is the first category of definition? It's a means definition. Best example, the definition of company. Definition of company as per section 2 class 20. What is the definition? Company means. Company means. What is the definition, sir? It means definition. Company means a company which is incorporated. Which is incorporated under this act or any other previous law. Any other previous law. Okay. The company means a company which is incorporated under this act or any other previous company law. That is nothing but it's a means, it's an exhaustive, completed definition. What is company? It's an exhaustive definition and completed definition. Company means. So another definition, sir. Another definition is nothing but includes. Includes definition. So what is the include definition? You know about Securities Contract Regulation Act. What is the definition of securities? Securities according to section 2 clause H of Securities Contract Regulation Act, securities includes Securities includes any shares, debentures, stocks. Okay, sir. Shares, debentures, stocks, mutual funds, derivatives, any units. Like that, what is the incident means includes securities 2 and class H. Okay, so like that, it includes definition, sir. It is includes this one, and also saying you know about sale of goods act, sale of goods act. So in case of sale of goods act, there is a definitions are also there. Goods includes goods includes all movable property, all movable property except actionable claim. So like the definitions are defined. One is means it is a exhaustive, completed definition. Includes means you wanted to add anything in future, you can add also, no problem. Includes means it's not an exhaustive definition. Last category of definition, it means and includes. Means and includes. Both two concepts are entitled. Just example, share definition in Companies Act. Share means share in a share capital, share in a share capital which includes stock also, which includes stock also. Like that, the definitions are broadly classified into these are the three different categorizations. One is a means related definition, another one is includes related definition, another one is a means and includes definition. This example company means it's exact definition. Next, securities includes or share means share in a share capital, which includes stock also. Like that, the definitions are these three different categories of definitions. Any definition be correct. Any type of definition based on the authorities that is correct. This is another situation, and also one more important point. So whenever you are defining the words, you can use the words shall and may. So basically इसका meaning क्या है? सर shall is nothing but mandatory. May is nothing but optional. Shall is nothing but mandatory. May is nothing but optional. It's a basic understanding. Yes, sir. Shall means mandatory. May means optional. But some situations in law, shall may be treated as may and may be treated as a shall. Best examples are whenever you are discussing about a company, sir, company section 3, company may incorporated, company may incorporated for lawful purpose. Company may incorporated for lawful purpose. So here, whenever this is the statement in law, sir, law gives this statement: company may incorporated for lawful purpose. Whenever we are read this particular statement, there is a wrong interpretation in our mind. So company may incorporated for lawful purpose. इसका मतलब क्या है sir? Company may incorporated for unlawful purpose also. That is the way you are thinking in your mind. That is wrong. Why? Because the law clearly says that it can be mentioned may, yes, but it cannot be treated as a may, it is treated as a shall. Shall का मतलब mandatory, may का मतलब optional. Sir, but here, even though here the word may is mentioned, but it is not may, that can be treated as a shall. Company shall incorporate it for lawful purpose. But Companies Act law defines company may incorporate it for lawful purpose. Okay, sir. Why, sir? Why simple scenario, sir? Today liquor business is valid in India. Then today it is lawful business. Tomorrow liquor banned. Then that will become an unlawful business. Then that is nothing but may incorporated for lawful business also. But may mention chesina, but it can be treated as shall only. This is nothing but the differentiation of words between the shall and may. Okay, so listen. what topics we are discussing now, go through with that. Right, sir? Screen is visible. The screen is visible now, everyone? Yes. Situation. Listen. So preamble. Every act has a preamble. Every act has a preamble which express the scope and object and purpose of the act. Preamble in the sense what purpose the act was introduced, what is the scope of that, what is the object of that that can be mentioned in the preamble. This is the main source for understanding the intention of the lawmaker. As this is the main source and understanding the intention of the lawmaker. That is the reason why whenever you are studying about information technology, virus is one definition. You are studying about Environment Protection Act, virus is one. So how you can identify based on preamble only you can identify. Whenever there is an ambiguity in understanding any provision of that, preamble is accepted as a aid of construction. If you are facing any problem while you are reading the law, you are not having any means clarity towards interpretation, then you should refer the preamble. Based on that preamble, you should means interpret the word. Friends, the preamble of the Negotiable Instrument Act we are already discussed. An act define and amend a law relating to the promissory note, bills of exchange, and check. Okay. Preamble of Companies and Act consolidate amend law relating to the company. So how it already we have discussed how the bill becomes an act. Important to know that act is a bill passed by both the houses of parliament and assented to by the president, where a bill is a draft of a legislative proposal, but in the proper form, which is passed by both the houses of parliament and assented to by president becomes an act. On getting assent from president, an act is notified in the official gazette. How bill becomes an act? After becoming an act, what are the means contents in the act? First of all, there is a title, short title and long title. Short title for easy reference. After that, we will discuss about the preamble. Preamble will show what is the object and scope of the act, what purpose the act was introduced. After that, you are having the definitions. In that particular definitions, may after that definitions is every act contain definition part. The purpose of the particular act definitions are generally in section 2. But in the General Clauses Act, the definitions are defined under section 3. Okay. Out of these definitions also, some definitions are applicable to some acts, some definitions are applicable to some acts. There is nothing but partial applicability and complete applicability is there. Object and definition clause to avoid the necessary or frequent repetitions in describing all the subject matter to which a word or expression so defined is intended to apply. The normal not a matter. Securities are not defined. Companies Act is not defined, yes. It can be based on SCRA, 2H of Securities Contract Regulation Act. A word is equivalent applicable on the Companies Act. Similarly, digital signature used in the Companies Act shall be constituted Information Technology Act. Yes. Next one, sir. After we will discuss what means and includes. Some definitions, use the word means. Some definitions are exhaustive definitions and exactly define the term. Definition of a company, we have discussed company means a company which is incorporated under this act or any other previous company law. Or 234 defines a director. Okay, so some definitions are include definition. Some definitions include. Such a definition do not define the word but are inclusive in nature. What is the best example, sir? Debenture is there. Debenture defined as Section 2, Clause 30 of the Companies Act. Debenture includes debenture stock. Or where know about securities includes. Or goods include sale of goods act definition. Body corporate under Section 211 of body corporate includes foreign company but excludes cooperative society. So one more definition means and includes. Both are included. Best example, share. 284 defines a share. Share means a share in a share capital, which includes stock also. These are three categories of definition. One is exhaustive definition, another one is inclusive definition, another one is means and includes related definition. What are the examples for these three? After that, whenever you are maintaining the definitions, you can use the word shall and may. Shall का मतलब क्या है sir? It is nothing but mandatory. So may का मतलब क्या है sir? It is nothing but optional. The word shall be used. Rise a presumption of something which is mandatory or imperative, while the word may is used to connote something which is not mandatory but only director or enabling. However, sometimes the word may and shall can be interrupted interchangeably. Some situation, even though word you can use the word may, but that can be treated as shall. Best example, Section 3 of Companies Act. Company may incorporated for lawful purpose. Here, may ka matlab, so it is incorporated for unlawful purpose also, no sir. That it can be may, we mentioned the word may, but it can be treated as shall. After that, companies 21, Section 21, service of documents, we know about that. The companies provides a document proceeding requiring authentication. Authentication of document. How we can authentication of documents are generally company authentication common seal. But what happened? Companies amendment rules 2015. Common seal is deregulated. Instead of common seal, two director signature. Out of that, one is managing director or one director signature and one company secretary signature is sufficient. So like that, in this scenario, sir, like that, what happens, sir? You should mention, like that, you should mention, no? Okay, sir. Authentication of contract. Here they use word may, sir, may. So the contract made by on behalf of company may be signed by the key managerial person or officer of a company duly authorized by the board. Here may is nothing but may only, but some situation shall may can be treated as a shall. Okay, so listen. So after that preliminary section 1 short title, this is all we have discussed. This act is called as General Clauses Act. Short title section 2 General Clause Act has been repealed. Repealed का मतलब क्या है? What is meant by repealed? Repealed means cancelled. Repealed means cancelled. Okay, so this is the basic introduction related to the section 1 and related to the whenever you can frame the act, what type of definitions, means definition, includes definition, means and include definition, what is short title, what is long title, what is preamble. These are the concepts, the basic concept related to that. Now we are entering the contract concept is called as definitions. Now we will discuss about the definition. There is a simple thing, sir. What is a conflict of the provisions, sir? Best example, in case of prospectus concept, whenever prospectus are issued to the public, you can file to the ROC the 90 days validity to the prospectus. But coming to shelf prospectus is validity is 1 year. So there is a two provisions, two rules are contradicting each other. So coming to section 53 of Companies Act, issue of shares at discount is prohibited. Issue of shares at discount is, the company can issue the shares at discount, those shares are void. But coming to section 54, immediate section in the Companies Act, equity shares, those are issued at discount, that is valid. So contradiction between the two sections and the provisions are not. Whenever there is a contradiction, conflict between the two sections or two provisions or two rules in the Act, then who will solve it? Will this General Clauses Act can override that particular problem? General Clauses Act can solve this. Okay, this is the concept related, the basic concept related to the General Clauses Act. If you are clear about these concepts, and next आगे वाले parts are very easy, very easy. Okay, everyone is clear?